Hello, everyone. On behalf of York Hospital, I'd like to welcome you to today's webinar. Today, we are fortunate to share some time with Mary Kathryn Brennan, a partner in the law office of Brennan and Rogers with locations in York and Kennebunk, who will offer guidance on navigating important topics such as asset protection planning, dealing with age and disability, and ways to maintain our health and autonomy as we move through life. Today's webinar is sponsored by the Center for Older Adults at York Hospital as part of a series of educational sessions focused on maintaining both financial and physical health, as well as improving the safety, well-being, and quality of life for older adults in our community. York Hospital would like to give special thanks to the Maine Health Access Foundation for supporting this series. Before we get started, we do have a few quick housekeeping notes to review with you. Unlike traditional Zoom, where you see everyone's faces during the meeting, during this webinar, you will only see the presenter's face and slides. As participants, your audio has been muted, so if you do have a question, you should type it into the Q&A button located at the bottom of your screen. Please do not use the chat or raise hand icons, as those will not be monitored during this presentation. If you ask a question through the Q&A feature and it is not answered for some reason during this meeting, please feel free to email us at info@yorkhospital.com and we'll reply after the webinar concludes. Additionally, today's webinar is being recorded and will be available for viewing on York Hospital's YouTube channel sometime early next week. So once again, thank you very much for tuning in today and spending this time with York Hospital. We hope you find the information helpful, and we're pleased to get started by turning the program over to Mary Kathryn Brennan. Thank you.
Thank you so much, Hillary. So just as a brief introduction, again, my name is Mary Kathryn Brennan. I'm a partner with the law firm Brennan and Rogers. We're located in York and Kennebunk, Maine. I have been an elder law attorney since 2006. Between 2006 and 2011, I was a staff attorney at Maine Legal Services for the Elderly, which is a nonprofit law firm focused on a range of elder law issues. From 2012 to the present, I have worked at this firm, which is currently Brennan and Rogers. My husband, Smiley Rogers, started the firm before I joined him. So formerly, it was called the Law Office of Smiley G. Rogers. So I say that by way of introduction and to let you know I have about 15 years of experience focused on elder law issues, and I am hoping to share some of the information that I have learned the hard way over time so that you do not have to learn it the hard way. So we'll start with the next slide that talks about what people think about when they think about what estate planning is. Many of my clients come in here and they are very focused on what happens to their assets after the time of their death. And from my perspective, estate planning is much more dynamic than that. And in this office, there is a real focus on what is going to happen to your autonomy and your assets during your life. And we place probably more focus on that issue or that set of issues than we do on the questions of what happens to your assets after you die. Okay. Planning for incapacity is sort of at the center of everything that we do here, making sure that if you did become incapacitated, we know who is going to manage your finances, who is going to make your healthcare decisions, how we are going to optimize your assets to make sure that you can access long-term care on your terms and optimize the outcome for yourself and your family. So on the next slide, we start talking about these big questions that we want to answer whenever we're meeting with a new client. So we really need to think through who our family members, our friends, our loved ones, who are the right people to serve in these roles of surrogate decision-making if you could no longer speak for yourself or handle your own affairs, right? Who's going to be the one to pay your bills, to file your income tax returns, to make sure the real estate tax check gets there in time, right? And then who is going to be the person to advocate for your long-term care wishes, your end of life wishes, right? Your quality of life questions. Those people might be one and the same. They could be different people in your life. And if you don't make the decision in advance, right, we end up in a situation where you could someday have your family and friends before a judge who's going to make the decision for you. And of course, the judge is not well situated to know who in your life would be best suited to perform what's really a pretty broad range of tasks. So we encourage you to think about it and plan about it in advance. It's also important to start the conversation both for yourself to really consider the questions of what types of interventions you would want if you needed end of life care and you couldn't communicate your wishes any longer. So making those decisions for yourself, which is the first step of the process, and then adequately communicating them to the individuals who are charged with making your decisions if you were to become incapacitated. So we're going to break down these roles of surrogate decision-making and the tools we use to plan ahead for these contingencies, starting on the next slide. So when it comes to our finances, we recommend really that any individual over the age of 18, over the age of majority, execute a durable financial power of attorney, okay? And there are a couple of aspects that are important to understand regarding financial power of attorney. One is we sign a power of attorney and we often make it effective immediately while we are capacitated to know who we are picking to serve in these roles. But we indicate that the power of attorney is durable, meaning it endures our incapacity. Right? Even after we become incapacitated, our agent should be able to act for us. The legal construct behind any power of attorney is what is called a principal-agent relationship. So the principal is like the boss, right? I am the boss executing my own power of attorney, and I am appointing an agent, in my case, my husband, to take care of my bill paying, my income tax returns, my insurance issues if I were to become incapacitated to do it myself. As the principal, as long as I am clear and capacitated, my agent has to take direction from me. Only if I become incapacitated can my agent become my surrogate decision maker, meaning making decisions without my input or authority. And his job is that if I did become incapacitated and he was in the role where he needed to start making financial decisions for me, his job is to say, not, my husband's name is Smiley, if you can believe that. Yet Smiley's not supposed to think about what Smiley would do if he were confronted with this financial decision. Smiley's job is to think, what would Mary Kathryn tell me to do if she could communicate with me right now? Right? A surrogate decision maker, not in that you substitute your judgment for the principal, but you're trying to carry out what you believe their wishes would be. So that's the job of an agent under a financial power of attorney. And as you can imagine, many of you are probably thinking about your families and thinking, oh yeah, there are a couple of people in my family who would be very well situated to do that. They are organized. They are good with numbers. They take care of things in a timely fashion, right? And they are willing to follow up on details, particularly financial details. And so there are certain people in your sphere who are most likely going to be well suited to perform these tasks. And you want to think about who they are and in what order, okay? Our goal in a financial power of attorney is to include everything but the kitchen sink in the authority that we give to our agent, okay? And the reason for that is if you don't have a financial power of attorney, and you become incapacitated, your loved ones, including your spouse, if you can believe it, have no authority to access any assets that they are not owners of. Okay. And the way that this comes up most frequently in my office is we'll see one spouse becomes incapacitated. The other spouse needs to access money in an IRA or a 401k. Those types of retirement accounts, by definition, cannot have a joint owner. They are simply owned by the taxpayer that contributed the money to them, right? And so the outcome is, if there is no financial power of attorney that allows the spouse to access those accounts, I have to go up to probate court. If you live in York County, that's in Alfred. If you live in Cumberland County, it's in Portland. I have to go up to probate court and truck up there and go before a judge and make the argument that a spouse can access, what essentially should be a marital asset, right? The fix is simple by doing one of these documents. And hopefully you never need it and you are capacitated for the rest of your life. But if you do need it, it will save lots of time, hassle, and money if you have it in place in advance. We also specifically recommend that when you're doing a financial power of attorney, that you include authority to make gifts and to create trusts. Okay. Now there's a caveat on this. When I start going through a durable financial power of attorney with any of my clients, I often will make the comment, we're giving your agent the authority to take all of your money and go to Brazil, right? But we trust this person or these people enough not to do that, that we are willing to let that authority stand. So the message I always want to send to clients is, our ideal scenario with a durable financial power of attorney is that we have an extremely trustworthy agent that we are completely comfortable with their honesty and integrity. And then we really give them every power that we're authorized to give them, so that they never have to go to the probate court to petition for authority to simply take care of your financial affairs. When it comes to the ideas of gifting and creating trusts, those are powers that we include to optimize what planning could be done for an individual, even after they may have lost cognitive capacity. For example, if one spouse were to need to go into Durgan Pines and receive long-term care there, there is ability in the Medicaid regulations to move assets over to the spouse at home living in the community. But if the power of attorney does not specifically authorize it, it's not allowed. Okay, even if the power of attorney has every other power under the sun, if it does not allow the ability to make gifts, we're not allowed to do it without a court order. And we're back in the position where I have to run up to Alfred and see if a judge will agree to this. The same rationale applies to the ability to create trust. When we are planning for long-term care or planning for tax implications, or even planning for individuals who are beneficiaries of our estate who might become disabled in the future, right? If we don't have the if our agent doesn't have the flexibility to change how those assets will pass, we lose the ability to optimize how the plan might work without court intervention. So we recommend setting it in advance, but understanding that your agent has to be completely trustworthy. If you have any doubts, or if any doubts arise about your agent's ability to act in your best interest, our advice would be to revoke it and to replace that agent with someone else. Sometimes clients are very uncomfortable with the idea of making a financial power of attorney effective immediately. Our advice typically, as I said, is to pick someone trustworthy and make it effective immediately. And that's for a couple of reasons. The first reason is that typically when a power of attorney is springing, you'll see that reference on the slide, it isn't effective until 2 licensed physicians certify in writing that the principal is incapacitated. Okay. And the reason that we think that can be tricky is that for many of our clients later in life, capacity is not a black and white issue. You know, I have many clients who are fully capacitated until about 3 p.m., at which point they become disoriented. And I would need to go to a surrogate decision maker if I couldn't wait until their next period of lucidity to deal with them. And so, you know, clients frequently face a situation where capacity might be going up and down, and there may be times where they absolutely could make reasoned decisions about their finances and what path they would want to take. And other times in the same week, even, that they would be incapacitated to make those decisions. So it can be very difficult when someone is going down that path if you need to obtain physician certifications that someone is incapacitated, when in reality, that's not quite the full picture. The other thing is, even in a scenario where someone is truly incapacitated, for example, they are in an irreversible coma, if you needed to wait for 2 physicians to submit a letter in order to take financial action for them, that can create lag time and delay in planning issues that could otherwise be solved with a power of attorney that was effective when signed. In a power of attorney for finances, you also designate the individuals that you would want to serve as your conservator, okay? A conservator is defined as a legal guardian for your money and your assets, okay? And so the hope is, by executing a financial power of attorney, we never need to go to court and petition for a conservator. But you get to say in advance in your document, if I ever did need a conservator appointed for me, these are the people that I would like to serve in that order. The other thing I just want to raise, because I do see this frequently, is sometimes clients will bring in their documents and I'll review them, and I will see that they have a financial power of attorney, but the financial power of attorney simply appoints spouse and there are no successor agents. Well, that is certainly much better than having no financial power of attorney. But the downside is, after the death of the first spouse, there is no one in the waiting room to sort of step in and start making financial decisions for the surviving spouse. And so even when clients are on the younger side, we always recommend appointing at least one backup agent if the primary agent dies or becomes incapacitated. And we prefer 2 if someone has multiple options, where they'd simply serve in successive order, potentially spouse, child number 1, and my niece, or whatever the cast of characters ends up looking like. We just say, if you do have financial powers of attorney, dust them off, look at them, and make sure that there is contingency planning if your primary agent dies before you or becomes incapacitated, so we don't end up back in that scenario where we might need to end up at the probate court, right? On the next slide, we'll just review the execution requirements for a durable financial power of attorney. So as I said, this document creates a principal-agent relationship, all right? It does not give the agent any ability to override your decisions unless you become incapacitated, okay? This is a document that I do recommend executing with an attorney. There are statutory notices in our probate code that are required. And if those statutory notices do not match the statute word for word, I have certainly seen cases where power of attorney was declined for an agent to execute a deed at a real estate closing or open a bank account. So this is a document that can be very helpful in planning for incapacity, but it is extremely important that it meets the statutory requirements or it may not work for you. It has to be actually signed by the principal or at her direction in the event that she physically cannot write, but is cognitively capacitated to instruct someone to sign on her behalf in front of a notary. Okay, must be notarized. And if the principal signs the financial power of attorney in front of a notary, that meets the execution requirements in the Maine statute. But we do recommend adding 2 witnesses when possible. In our office, it is our policy to have 2 witnesses and a notary, unless there are extenuating circumstances and we're doing something very quickly because someone, is facing an imminent surgery or that kind of thing. Ideally, we're looking for 2 witnesses and a notary. All right. On the next slide, we're going to talk about planning for healthcare decisions, right? So unlike the financial power of attorney, where I think it's important that you see an attorney who's knowledgeable about this area of law in order to have the assurance that it's going to be usable when you need it, right? Because by the time you become incapacitated, it is too late to sign a new one. And if it's not going to cut the mustard, we have to go to probate court. When it comes to the Advanced Healthcare Directive, in a few slides, we will get to a wonderful form that's provided by York Hospital. And I can't say this enough. I would encourage you all, if you do not have a healthcare directive, or if your healthcare directive needs to be updated, download it this afternoon and get started. We're going to talk about all the considerations and the execution requirements. But the Advanced Healthcare Directive deals with who is going to advocate for your healthcare decisions if you are incapacitated to make them yourself. Okay. And again, this is one I definitely recommend that anyone over the age of 18 wants to consider doing. If there's anyone on the webinar that has children who are moving out on their own or going to college, I would recommend having those newly minted adults fill out one of these forms, because if your child is at UC Berkeley, right, and they get into a car accident, guess what? The hospital has no right to release any information to you as a parent if they're not cognitively capacitated to give that permission. The healthcare directive would be something you could send in, and it would say to the medical provider, this is an authorized person. It includes a HIPAA release. I can tell them what's going on. That's kind of an aside, but you understand the principle behind the document. So an advanced healthcare directive is a legal document that contains at least 2 components. Okay. And many of them, including the York Hospital form, contain more than these 2 components, which we'll go through in a moment. The first thing that it does is appoints 1 or more healthcare agents. So those are the people who are designated to advocate for your healthcare wishes if you can't do it yourself. And just as in the financial power of attorney, my recommendation is that if you have 1, in an ideal world, I would like to see 2 alternates behind your primary agent, so that if something happened unexpectedly and husband and wife get into a car accident together, well, we have 2 people sitting in the background ready to advocate for you. In an ideal world, if something happens to our primary agent, we have time to come in, think about the plan and adjust, but we don't want to rely on that. Okay. Then the second component that is in every advanced healthcare directive is what is colloquially referred to as a living will. In our office, we call it end of life decisions, because we think that the term living will is confusing, to say the least. So what a living will is, when someone refers to that, is basically a series of decisions that you make in advance in writing about what types of treatments you would or would not like if you were in an irreversible coma, a persistent vegetative state, or if you had a terminal condition and you could no longer speak for yourself, you were unable to meaningfully communicate anymore, either due to the fact that you couldn't speak at all, or if you had cognitive decline to the point where you could not make reasoned decisions. These questions go through items like, if you were in one of those states, would you want artificial means used to keep you alive, right? If you were in one of those states, would you want artificial nutrition and hydration? Would you want pain relief, and when? Would you want your agent to have the authority to execute a do not resuscitate order for you, a no code order, if you were in one of those states and you couldn't sit down with your primary care physician yourself to weigh the pros and cons of executing the DNR? Okay, so those are the kinds of considerations that you would work through when executing the end of life decisions portion of the Advanced Healthcare Directive. So you have one or more people to advocate for your decisions, and then you give them their instructions, right? You give them their instructions and say, if I'm in one of these states, this is what I want you to do or not do, all right? Many healthcare directives, including the York Hospital Association form that is going to be linked in your slides, contain other planning opportunities. So almost always we'll see a designation of guardian, right? If you were to become incapacitated, this is the person or these are the people that you would want to serve as guardian for you. Again, we're hoping to avoid going to the probate court to petition for a guardian by doing this document. But you know, if it ended up in court for whatever reason, you get to say in advance who you would want to serve. Many of these forms also talk about your wishes regarding organ donation, whether it's something you would want to do, and any uses that you'd feel comfortable with those organs being used for. Many documents indicate what your wishes are regarding funeral and burial arrangements. And I will say this, I have to put this plug in here, that it's very important. In our office, we think it's very important to designate who has the authority to carry out funeral and burial instructions, and to designate that in your healthcare directive, because in the event that there is any disagreement among family members, you can imagine that that issue would become extremely charged. And if in your healthcare directive, it says specifically who the person or people are who have the authority to carry out those funeral and burial instructions, that argument is sort of stopped right in its tracks, because that's a legally enforceable designation. You can also write in instructions about what your wishes are. Okay, so it's worth going through the effort to think about it, because the burial instructions that you put in your healthcare directive are often incorporated by reference and are enforceable by the individual who is designated to handle those arrangements for you. Your healthcare directive also will designate a primary care physician, and we recommend when you execute it to at least put one on file with your primary care physician. And also to consider putting it on file with any specialist that you work with on a regular basis. Our primary office is in York, as we've discussed, and we have many clients who are patients of York Hospital family practices. And what we have found is that as part of our file closing, we always send a copy of the healthcare directive to the primary care physician. And we found that at this point, there's relatively good success with having that healthcare directive pop up at any location in the York Hospital system that is part of the same set of medical records. So, you know, if you put it on file with your primary care physician and you give copies to your agents, the goal is when we need it, someone is going to be able to put their hands on it. Okay. And your healthcare decisions are something that you want to share early and often with your agents. Okay. There are certain questions in the end of life decisions or living will portion that are going to be legally binding on your agents. However, for most of us, we don't go from capacitated to incapacitated, right, overnight. It's not a black or white question. And so the healthcare agent, the more information that they have about your wishes regarding long-term care, home care, memory care, hospice care, all of those decisions that might need to be made for you if you cannot make them yourself, but come prior to the point where you're in an irreversible coma or a persistent vegetative state. The more guidance that you can give to your agent, the more likely it will be that your wishes are actually effectuated. All right, and on the next page, we will review the execution requirements for the healthcare directive, because you are all gonna do this by the end of the week, okay? That's your homework. If you don't have one already, it would be a great Christmas present to me if you did this by the end of the week. This is a great thing to do. Your family will thank you. You can check it off your list before the new year. And the next slide is going to have a link to a form that you can use. So once you fill it out and you've made all your decisions and you've designated your agents, you need to sign it in front of 2 witnesses. Ideally, these would be impartial witnesses, meaning individuals who are not appointed as agents in the document. 2 witnesses under the Maine Healthcare Decisions Act are all that is required for the healthcare directive to be effective. And so I would encourage you to go ahead and sign one as soon as possible with the 2 impartial witnesses, even if you can't make it to a notary. But I will say, our recommendation is if you can have it signed by 2 impartial witnesses and notarized, it would meet the execution requirements in all 50 states. And therefore, it is just easier to use it across state lines if you needed to. And of course, here in your county, we have many clients who receive treatment in Massachusetts, in New Hampshire. So we definitely will, a properly executed healthcare directive with 2 witnesses is way better than no healthcare directive. If you can get it notarized as well, all the better. And that's what we would recommend. All right. And then on the next slide, we'll just hang out here for a moment while you take some notes. But unlike the financial power of attorney, this is sort of a do-it-yourself situation. You can do it in an attorney's office. And if you don't have one when you come to see me or any other elder law attorney, they will make you do it because they know what the consequences are if you don't do it, and we need it. But this is a form that you can download and print. The link is below. I believe, and I apologize, Hillary, if I'm wrong about this, I believe that the slides are going to be made available to the participants after the presentation is over, and there is a live link to the PDF with that advanced healthcare directive. On the next page, I am going to simply stress again what happens when we don't do our financial power of attorney and our healthcare directive, in case you're not convinced yet. So the process is, I get a court petition, okay? And I fill out a bunch of paperwork stating that one or more of your family, you're incapacitated. I have to decide, if I don't know you, well, hopefully if you're my client, you have these documents and we never have to deal with this. If you are coming to me off the street and a friend or loved one is incapacitated, what we're doing is trying to assess who's willing to serve as guardian and conservator. We're filling out petitions for the court and sending them to the court. The court then appoints a special court-appointed court visitor to visit your incapacitated loved one and get their position on the court proceeding. The court gives that incapacitated individual the right to have an attorney appointed. All of your assets are publicly disclosed with the court. Okay, the actual asset sheet should be redacted in the online filing, but the court will see what all of your assets are. Then on an annual basis, your guardian and conservator will have to report to the court how they spent every cent of your money, the provisions that they are making for your health and welfare, and their plan for your health and welfare going forward into the next year. And all of this is public record. And as you can imagine, it is very time consuming and it is very expensive. Okay. And it discloses information that really should be private and between you and your family members. So these two documents, the Financial Power of Attorney and Advanced Healthcare Directive, are a simple and inexpensive solution to what can be a very expensive and vexing problem. And I will leave that there. I will get off that soapbox and we can move on to talking about long-term care and asset protection on the next slide. Okay. So one of the thorniest issues that I see with clients coming into the office is when someone gets to the point where they are having a hard time remaining independent and knowing what the right level of intervention is. Hopefully we've got our agent under our power of attorney and our healthcare directive who stand ready to help us implement a plan if we are at the point where we cannot make decisions anymore, right? To line up the needs that we need, the care needs that we have. And there are many considerations that come into play when we are considering the long-term care continuum, right? So ideally, we've done our estate planning well in advance and we have those surrogate decision makers in the event that we needed them to act for us. And of course, there comes a point in time at some point as someone's health is declining where you really want to touch base on a more frequent basis to see how things are going and if additional help is needed. And sometimes that can be very informal. It can be family help or family caregivers. It can be hired help coming in to help out with household tasks. And then at some point, many clients that I work with are looking to loop in home care or true residential care options, either assisted living facilities or nursing facilities. And the way that we are using that financial power of attorney and that healthcare directive at that point is to optimize the outcome based on the client's goals as far as where they want to live, who they want to live with, the setting that is most appropriate to meet their care needs, and also the financial aspect of it. What will Medicare pay for? What might the Veterans Administration pay for? What can we pay for privately? Or is there a long-term care insurance policy that we should start to loop into the conversation? And a lot of clients are concerned about these issues because, as I'm sure many of you are aware, if you were to need long-term care in a nursing facility, for example, in York County, that monthly bill is in the sort of $10,000 to $13,000 per month range. And so it can be a shock if clients have not prepared themselves for this in advance when they realize what the outflow will be on a monthly basis and what impact that might have on their estate. Okay, so there is basically all of the assets owned by either spouse in a marriage are countable assets for purposes of means-tested public benefits. The most common means-tested public benefit that is used to pay for long-term care is Medicaid, or we call it Maine Care here in Maine, although there is a version of the Medicaid program in all 50 states. And if you want to move assets out of your name in order for them to be protected from long-term care expenses, there is a 5-year look-back period or a 60-month look-back period to that transfer. And there are a number of ways that you can do it. You can make outright gifts. You can make gifts into what are called irrevocable trusts, meaning trusts that you can no longer change once they are executed and funded. Okay. And there are a lot of considerations in play when we decide, is that the right thing for a client to do? You know, a lot of my clients will come in here upon an initial meeting and saying, hey, can I just put my assets in a trust and then run out the 5-year look back period and they're protected after that time? And the answer is possibly, but no. And this is the huge caveat, that anything that you put into an irrevocable trust to run out a 5-year look back period, you have to give it away. Right? You cannot retain an interest in those assets. If it's a home, if the home is sold, the proceeds cannot come back to you. So it's not the right approach for all clients. And for many of my clients, in fact, once they come in and ask about this planning and I say, okay, well, what are you willing to truly give away and not get back during your lifetime? That subset of assets is what might be a candidate to fund an irrevocable trust. Okay. Now, when it comes to two spouses with one spouse who needed care in a long-term care setting, a nursing facility or an assisted living facility, and there's one spouse who's living at home, there are a lot of planning opportunities that I can do as long as I have the healthcare directive and the financial power of attorney with that gifting authority to move assets back and forth from husband to wife or from spouse to spouse with no 5-year look back period and no transfer penalty. So for two spouses, we have a lot of flexibility to plan even at the 11th hour for Medicaid. And for a single individual, really the only option in most cases will be to transfer an asset at least 5 years or 60 months prior to needing financial help paying for long-term care. But when we're thinking through these issues, we always have to consider all of the different factors. You know, it could be that applying for Medicaid may protect some of your assets, but it may negatively impact where you're able to receive care geographically, or if you're able to receive home care, if you're in a private room in a facility or a shared room. So there's a very big conversation that you need to have around this whole issue of the 5-year look back period when we're thinking about planning in this way. All right. And now we can move, I believe, 2 slides in advance. Yes. See, I got ahead of myself, guys. I'm sorry. So this was the slide I was just talking about. So in summary, the role of estate planning is that we have surrogates to make decisions for us, that there's flexibility with trustworthy agents who have clear direction and they can act in an organized and efficient manner. So that is my 10-cent tour through important concepts in planning for incapacity and for your estate. And I believe that York Hospital has a poll to consider before we get to Q&As.
Yes, thank you very much, Mary Kathryn. That was terrific. And we did want to launch a quick poll. If you would, any of the participants, if you would just choose your answer, and then we'll move on to the question and answer session.
I'm choosing to.
We'll give everyone another 30 seconds to complete the poll. Thank you very much.
Thanks, Hillary.
And we did want to remind you all that if you have a question, if you would just type that into the Q&A icon that you see at the if you hover at the bottom of your screen, you'll see there's a Q&A and there's a chat. Put your questions there in Q&A if you have them.
And Hillary, let me know when you're ready. There are a couple of questions that I had received in advance. So
Okay, terrific.
just let me know when you're ready.
It looks like we did have somebody submit a question. The question is, my nearest relatives' nieces live in Virginia. Does it make sense to have them as my executors?
So from my perspective, the answer is probably yes. If they are, if they are trusted confidants of you and they live in Virginia in this digital age, when it comes to financial management, honestly, that can happen from just about anywhere. And the real question is, are they organized? Are they efficient? Are they going to be the individuals who will step in and help out if you become incapacitated and need financial help or need someone to help with healthcare decisions? The other thing that I will say is there are professionals who act as financial agents or healthcare agents for a living, right? But I usually say to clients, if you have a family member that you have confidence in and you trust, there would be nothing that would prevent that family member from hiring a professional to actually be the one to manage the bill paying. But they are overseeing them and have the ability to hire and fire them. So even if you're dealing with a trusted family member who couldn't perform all the tasks him or herself, no one's going to care more about the outcome for you or know you better than they will. And certainly, an attorney could guide them toward individuals who they could hire to help with the actual performance of tasks if it was too difficult to do remotely.
Thank you. And it looks like we do have one question that was just submitted about protecting assets in the 5-year look back. And I think that is the same topic as some of the questions that came in advance.
Yeah.
So maybe we could I have heard the term Medicaid compliant trusts. What does this mean?
So probably unsurprisingly, that the answer to that question, I could go on for 60 minutes, but in essence, what it means is that the individual who sets up the trust, they appoint someone other than themselves or their spouse as the trustee of the trust. They appoint someone other than themselves or their spouse as the beneficiary of the trust, meaning they can't be in charge of it. They can't be the beneficiary of the trust. And then they give one or more assets to the trust. Sometimes it is a piece of real estate. Sometimes it is a chunk of liquid assets or cash, stocks, bonds, CDs, business interests, and they put them in the irrevocable trust. The date that those assets are transferred to the trust, that the grantor has no control over anymore, cannot receive distributions from anymore, that starts the 5-year look back period. Okay. And really the grantor, the powers that can be retained by the grantor in order to start a Medicaid compliant trust are minimal, if any. So you have to be, the goal behind a 5-year look back trust is really, I want to protect one or more assets or an amount of money for the benefit of the next generation or for the benefit of your debesees, right? It's not something that we typically do to protect assets for one spouse to the other. It's something that we're doing when there's one or more assets that we really want to make sure goes to the next generation.
Okay, thank you. Well, I know that you are going to take some time to answer these look backs. The one that was, what are the different ways to protect assets for the 5-year requirement was submitted. And I think you have a couple that you received in advance as well.
Yeah, let me just field I think that the questions I received in advance do encompass that. So the first one, I'll read it and then respond to it. If you have a revocable trust, does the 5-year look back start the day the trust is finalized? And the answer to that question is a revocable trust does nothing to start a 5-year look back period at all. And it's a great question because clients do come in with revocable trusts and they say, oh, I did this more than 5 years ago. Isn't this part squared away for my long-term care planning? And the answer is no. A revocable trust is one that the grantor could change or revoke at any moment. So it's considered fully available for purposes of long-term care expenses. A revocable trust is something that folks will do more to avoid probate, which is a different objective. And then the follow-up question was, what is the difference between establishing a revocable trust versus an irrevocable trust? And of course, it's just like it sounds, right? A revocable trust is fully countable in the assets of the individual who sets it up, meaning it starts no 5-year look back period and has no benefit for long-term care planning. It does have other potential benefits, but that's outside of our conversation right now. An irrevocable trust is one where the grantor sets it up and they retain no right to change it or modify it or take the assets out of it. The date that the 5-year look back period starts is the date that assets go into the trust, right? So if I sign an irrevocable trust tomorrow, but I don't put my primary residence into it until 6 months from now, it is 6 months from now. That is the date that the 5-year look back period starts, the date I contributed the asset. And the second question I received was, if there was a known way to protect your assets from the 5-year look back period, why don't more people do it? And I think the simple answer is, when I review with clients, listen, if you want to get this asset out of your estate for long-term care planning purposes, you really need to give it away, and you can't get it back for your own retirement or if you have an emergency. Many of my clients will just say, oh no, I don't want to give away my assets during my life. I want to retain control over them. I would say that is the number one reason that clients don't do this planning. And I would say, of the clients that come in asking me questions about this type of planning, probably 75% to 80% elect not to do irrevocable trust-based planning because they don't want to give up control. So I would say that is, I think that clients don't necessarily understand that you can't really have your cake and eat it too when it comes to long-term care planning. And when they realize they have to give up control during their life, might reconsider. Any other questions?
We do, actually. If I give money to Maine Public right now and get interest, does that have a 5-year look back?
So I think what that person might be talking about is a charitable remainder trust, or a charitable annuity. And the answer to that question is yes, it would incur a 5-year look back period. And how big a deal that is kind of depends on how big the gift is in relation to the size of your whole estate. Okay. So when we talk about a 5-year look back period, just briefly, the size of the gift really matters, because the way that you are penalized for a 5-year look back period is the total amount of the gift is divided by the average cost of care in a facility in the state of Maine to get the length of the penalty. So, for example, if I give away the current average cost of care of a facility in the state of Maine is $8,476. That's the divisor that the Department of Health and Human Services uses. Of course, down here in York County, you would never be able to find long-term care at that dollar figure, but we take all the figures in the state and that's what comes out of the calculator. So if I gave away $8,476 and within the next 5 years, I needed financial help with my long-term care and I applied for Maine Care, well, 8,476 divided by 8,476 is 1, right? That's the number of months. 1 month, Maine Care will not pay for my care. And then starting in month 2, my penalty period is over and they will start paying for my care. Contrast that with the hypothetical where I give away $84,760, right? They find in the 5 years prior to my applying for financial assistance with care, I gave away $84,760. They divide that by 8,476 and they get the answer 10. Well, now Maine Care is not going to pay for my care for 10 months, right? And at a rate of $10,000 plus per month, that's $100,000 that I have to come up with, even though I'm already out of money to pay. So I guess the message is the size of the gift really matters when you're considering the impact of the gift on your long-term care planning. If you're giving $100,000 to Maine Public, but you've got $900,000 in the bank, well, you know, it's not as much of an issue because you have the ability to pay privately through that 5-year look back period. Hopefully that puts it in context.
Yes, very helpful. And I think it looks like we have time for maybe 2 more questions.
Sure thing.
We have, what are the benefits of putting your property in a trust?
So it depends on what type of trust, of course. When it comes to a revocable trust, the primary benefit is to avoid probate. Okay. Also, when it comes to a revocable trust or an irrevocable trust, the only individuals who have a right to review the terms of the trust are the qualified beneficiaries. So there's definitely an increased level of privacy with trust-based planning. If you have a will, that will goes to the probate court at the time of your death and it becomes public record. Now, for many people, privacy is not a significant concern. Their will says, hey, if I die, give my property to my spouse, then my 2 kids. Like, no one is surprised about that, right? So different people have different thresholds, different reasons that they might want privacy or might not prioritize privacy as much. So privacy is a big factor. Avoiding probate in either case is a bonus. When it comes to a revocable trust, as I said before, there is no asset protection. All of the assets are considered available for purposes of long-term care expenses. Another advantage to revocable trusts is that we can do estate tax planning in revocable trusts where appropriate. I have not belabored estate tax planning because our exemptions are so high at this point. It's north of $5.8 million for a single individual for each individual in a marriage who's a Maine resident. Federally, it's north of $11 million. So it's not a common problem that clients have. Now, when it comes to an irrevocable trust, the biggest advantage, and really arguably the only advantage to establishing an irrevocable trust is once you've put an asset into an irrevocable trust designed for long-term care planning, that asset is beyond the reach of your long-term care creditors 60 months or 5 years after it is transferred to the trust. So I would say that is the significant advantage. There are individuals also who, if they need to do estate tax planning, if they have a higher net worth, we will establish irrevocable trusts to hold life insurance policies that are designed to pay estate taxes. That's much less of a common use. Does that answer your question?
It looks like they still were a little bit curious about if it was irrevocable, can you still live on the property while others have control of the asset?
Yes. Yes, okay. If you transfer, and that I will say that is common, that clients, if a client does decide that they're willing to give up control of assets and the goal is to protect the asset from long-term care expenses, more often than not, it is a primary residence. The reason being, the asset can go into the trust, but the individual who transfers it can retain a lifetime right to use and occupy the real estate. Right. And we can put a certain set of restrictions where the trust cannot be terminated until the death of the grantor. So I would say that the most popular asset to place in an irrevocable trust is the primary residence for that reason.
Thank you. And I think our final question will be, does a spouse have to transfer assets to the other prior to applying for long-term care, Maine care?
It is not required. Well, I should say there are two different sets of eligibility rules, and this is a little bit in the weeds, but I'll give you just like the 10-cent tour. So in a residential care, if someone's applying for Maine care in an assisted living facility, the answer is yes, it must be transferred to the spouse at home before you apply, or they will be ineligible. If the spouse is applying for care Medicaid for nursing facility benefits, there is a regulation that gives the applicant 1 year from the date of application to clean up the asset transfers between spouses. But our recommendation is always to try to get that tidied up before the application is filed. The goal being that we avoid what's called estate recovery. Okay, so if there's an applicant who needs Medicaid and they start receiving it, their income would go to the facility. Medicaid would pay the difference between the applicant's income and what it actually costs to keep them in the facility. And then at the time of death of the applicant, that bill, that estate recovery bill, is collectible against anything in their estate. Well, the goal is, if we've got a healthy spouse at home, we want to move those assets out of the estate of the applicant so that they are not available for collection on the death of the spouse who received Medicaid. Okay. And just to stress it again, if that spouse who's receiving care in a facility is incapacitated, the only way I can do that is if that spouse has a financial power of attorney with gifting authority, which is why we stress it so much on the front end in planning.
I think this is such a popular topic that questions keep pouring in. I don't know if you have the time to answer another 1 or 2 questions, or if we should send them to you by email to help.
I would be happy to try.
Okay, wonderful. Thank you so much. So we have, can you give an idea of the costs involved for setting up a trust with a healthcare directive, et cetera?
Yeah, so I would say, and I do interact with many of the elder law practitioners sort of in Southern Maine. And I would say that the range of what you would be talking about to set up an irrevocable trust, in addition to all of the planning documents, depending on where you went, might be in the $4,500 to $8,000 range, just depending on which firm and which attorney you were working with.
Okay, thank you.
Sure thing.
And are there no circumstances under which an irrevocable trust can be revoked? For example, the person who is named in the irrevocable trust allows you to revoke the trust.
So an irrevocable trust can never be revoked. All right. However, distributions can be made from an irrevocable trust to the beneficiaries. Okay. So that's not a matter of terminating the trust per se. It's a matter of distributing the property to the beneficiaries of the trust who are not the grantor. So there are circumstances where individuals will set up irrevocable trusts for purposes of long-term care planning, and then shortly after setting up the trust, unexpectedly they have a health event and they realize, I'm not going to be able to make it through the 5-year look-back period. In that scenario, the trust has failed its purpose, and what we would do, our escape hatch there would be that the property would be distributed to the beneficiaries, who are often the adult children, and the beneficiaries would, out of the goodness of their hearts, they are under no legal obligation to do this, they would transfer the property back to the grantor to solve the problem so that we could get Medicaid for the individual who needed it. So is it possible? Yes. Should it be the plan? No. If you plan on needing the assets that you put into an irrevocable trust within 5 years of funding it, my answer to you is, this isn't the right plan for you. It's going to fail. Okay, well, thank you very much for staying on for those last questions.
and thank you very much for your time today. I think that has brought us to the close of today's presentation. And to all of the participants on today's webinar, we appreciate the time that you've spent with us, along with the opportunity to share this very important information with all of you. Thank you for coming today, and best wishes to everybody for a happy and healthy holiday season. Thank you.
Thank you, everyone.